Good afternoon, everyone. My name is S.P. Kothari, and I am the SEC's Chief Economist and Director of the Division of Economic and Risk Analysis. It is my distinct pleasure to welcome all of you to today's third plenary session, Research Needed to Fill Policy Gaps. Before we begin, let me offer my usual disclaimer that as an SEC employee, I want to let you know that anything that I say is my personal views and it doesn't reflect SEC or SEC staff views. Excuse me. Today's panel brings together three prior SEC chief economists. I'm in August's company here. I will introduce them in the order of their public service. Eric Siri is a professor of finance at Babson College. His research interests include the interaction of securities law and finance, securities market structure, and other topics. He was the director of Division of Trading and Markets of the US SEC from 2006 to 9, and he also served as a chief economist from 96 to 99. So he has done double duty. And currently, and he was an assistant professor of finance at Harvard Business School, and currently, as I said, he is at Babson College. Second is Chester Spatt. He is Pamela R. and Kenneth B. Dunn Professor of Finance at the Tepper School of Business at Carnegie Mellon University, where he has taught since 1979. He served as chief economist of the SEC and director of its Office of Economic Analysis from July 2004 through 2007. I remember when he was there, I came to give a talk. So I've known Chester for a long time. Thank you. Good to have you here, Chester. And he earned his PhD in economics from University of Pennsylvania. Apart from being a prolific scholar, he has served as the executive editor and one of the founding editors of Review of Financial Studies. Craig Lewis is the third speaker here. He's the Madison S. Wigginton Professor of Finance at Vanderbilt University's Owen School of Management. He has held regulatory positions as director, Division of the Economic and Risk Analysis, US SEC Chief Economist, US SEC Vice Chairman, Committee on Emerging Risk and International Organization of Securities Commissions, that's a mouthful, IOSCO for short, and he was also an economic fellow at the US SEC. He has Master's and PhD in Finance from University of Wisconsin. With that, let me offer very brief introductory remarks and then turn to our speakers for a discussion. Before we get to the meat of the panel, I would like to provide a little background information about the work of economics within the SEC. Most of the agency's financial economists work with me in the Division of Economic and Risk Analysis. About half of the division's 150 employees have PhDs in finance, economics, accounting, and related disciplines. This is a lot of intellectual horsepower. But on the other hand, we make up less than 4% of the SEC labor force. It's a large place, SEC. So that less than 4% statistic might make some believe that economics is not as important to the SEC as one might think. Well, that's what we are here to debate. So with that, let me ask Eric, perhaps, what role do you think economics plays within the SEC?
You know, I say that economics has a very important potential role to play at the SEC. Unlike the Fed, which I think has always been an institution with a very, very strong economic underpinning, the primary language of the SEC is law. It's an agency of lawyers, which in many ways is as it should be. And that's especially true because besides crafting policy, it enforces rules and will take firms and people to court But the things that the SEC oversees are consummately economic. It oversees the capital markets, the capital raising functions. It oversees the trading markets. And so economic research and analysis have a critically important role to play in that it informs policy in a way that legal analysis just can't. So let me give you one short example. And for that, I picked the importance of the price. Economics cares a great deal about price formation, and it understands that preserving a price that's as reflective as possible about fundamental economic forces, that's key. I'm not making a statement about market manipulation, but really about supply and demand. And this comes into many aspects of what the SEC does. So for example, just picking a range of topics. In the IPO process, book building, coming to a reasonable price for the process that gives you an IPO initial offering price. Price formation and liquidity in secondary markets, ensuring that the credit rating agencies are free from undue influence and provide a signal of default probabilities to issuers. All of these are critically important, and I'm not here to say that attorneys don't think that they're important, but economists bring a special toolkit to that problem. And I think it's critically important that those economists' voices are heard and reflected in policy.
Thank you, Eric. Chester, perhaps you want to comment on that same question?
Yeah, I'll comment on it in a way that's complementary, but somewhat different in focus. I'll use as sort of a launching pad the role of methodology. Economists bring a different set of methods, both conceptually, i.e. theoretically, and empirically, as compared to the legal staff at the commission, which are the bulk of the commission's employees. And I think to a fair degree, the role of economics is then manifested itself by both internal analyses of the economics staff, and also by the analysis that are done by outside scholars, and how those are then brought to bear in the rulemaking process. I think a recent legal situation bears particularly on the role of methodology, and that was the example in June of the District of Columbia Circuit Court of Appeals basically blocking the SEC from moving forward on a pilot study on a particular issue in market structure. And, I think that kind of focuses sort of sharply a bit upon the potential role of economists at the agency, both in a positive way and in a negative way. On the positive way, I think in the negative way, it gets in the way of the SEC undertaking natural experiments. I think actually that kind of occurred because of the way the legal arguments were framed. I think not framed very well before the DC Circuit. But I think also so that's in the negative way, but I think in the positive way with respect to economics, the court ruling really highlights the potential value and importance of the types of evidence that economists routinely generate, both conceptually and empirically, and the importance of that being presented as part of the broader arguments that the commission undertakes. That's clearly what the court ruling called for.
Thank you, Chester. I don't know if I should say anything to defend the SEC. No, I'm just kidding.
Well, my criticism was of the appellate group. Just to be clear,
I know, but still,
it was not a criticism of DERA.
Craig, your thoughts?
Great. So I'm going to revisit this in a little bit, but at one level, I want to think about why are economists important at the SEC? And I think it spans both rulemaking, the policymaking space, as well as supporting enforcement and doing data analytics. So I'm going to briefly touch on rulemaking. And why is rulemaking necessary? Well, in general, it's designed to alleviate or correct a market failure, right? And so market failure, simply defined, is when private action, private incentives are insufficient to result in an efficient outcome. Regulation can play a role of trying to address that in a manner that benefits society. All right, so that's the idea underlying rulemaking. The big problem, as I see it, is policy is inherently a political process. The SEC's chairman and commissioners are political appointees, and although it's an independent agency, not only do the primary decision makers at the SEC have different political orientations, much of the policy work that the SEC actually is engaged in is determined by Congress. Congress passes the Jobs Act, the Dodd-Frank Act, and then those are brought to the SEC to implement and promulgate. And so at the end of the day, when I look at how policy making takes place, one person's market failure is not necessarily another person's market failure. Right? And so what happens, and the role that economists can play in this, is they bring a rigor, they bring a structured way of thinking. As an economist, I think about systems, I think about how things interact. As an attorney, I think that attorneys approach the problem, to touch a little bit on some of Chester's ideas, in a completely different way. And my anecdote will be, I taught at Vanderbilt in the law school with law professors. And I discovered that the way lawyers are trained is fundamentally different than the way I train MBAs. Lawyers learn through studying precedents and cases. In a sense, they build their knowledge base up by understanding a lot of anecdotes. Whereas an economist has a theoretical structure, a rigorous way of tackling problems. And so to me, economic analysis brings rigor to the debate, to bring rigor to discussion, and forces decision makers to address what might be inconvenient truths that can get swept under the rug. And the SEC has had some problems with this in the past, where certain economic ideas aren't fully vetted in their rules, and it led to the vacation of some of the rulemaking in the DC Circuit courts. And I think the reason this occurs is because, as an attorney, attorneys have a very client-focused orientation. The rulemaking attorneys in the divisions tend to think like attorneys and they try to establish ways of preparing and sort of the rulemakings that are designed to satisfy the chairman, if you will, right? And so it can be a little bit opportunistic at times, or it has been in the past. Where economics and where economists come into play is trying to break that client orientation and force people to look at things in an objective manner. The other part of where economists really play a role is bringing a lot of the data analytic econometric techniques to bear to help support actual enforcement cases. So a lot of the people that SP directs aren't doing policy work, they're actually helping enforcement. And the things that they do is they do data analysis, investigation of trading and trading ledgers in an attempt to establish whether somebody's engaged in insider trading. I know one of the things that we worked on quite a bit when I was there was trying to build up the risk assessment functions at the SEC and sort of bring more of a data-focused approach.
Did we lose him?
I think we might have temporarily.
That's what it does when he was enjoying time in Florida. So, now that was quite helpful. Craig, are you back?
I hope so. Can you hear me?
Yep.
Now we can. Yes. Go ahead. Finish your thought.
Well, I'm not sure when I got cut off. It was probably the ghost of Mary Shapiro cutting me off, but nonetheless.
Yeah. Did you say something nasty about her? So.
Jay Clayton has his hands on the controls. I basically, I'm not sure where I was cut off, but I was basically, did you hear my point about client orientation?
Yes.
Yes.
All right. Did you hear my points, my sort of my summary points about the role of economics in enforcement and compliance?
Yes.
All right. That's pretty much what I had to say.
Okay. Okay. It is interesting how we as economists use market failure and moral hazard and those adverse selection. And these are all pejorative. I mean, so laymen kind of, when I have conversation with them, and they always, their reaction is, oh, what are you doing? All these crooked things that you have to deal with. But so I wish we had crafted some different terminology that is not as pejorative. But I know all of you use the term rulemaking frequently. And maybe Eric, in your time at the SEC, I'm sure you were architect of several rules. So for the audience, can you tell just in a nutshell what rulemaking is?
Sure. The SEC has the authority to craft rules, which are really laws that govern our security market. So it's important to remember that the SEC has the authority to oversee our stock, bond markets, as well as the companies that issue stocks and bonds, and the brokers that trade them. The SEC also regulates exchanges, clearing agencies, and credit rating agencies. All of those entities have to operate under a set of rules. So the regulatory framework that's operated by SEC is one of rule promulgation. And thinking about it, I broke it down into 6 steps. There aren't any official 6 steps, but just for purposes of exposition. The first step would be the SEC's monitoring the landscape. Craig used the word market failure, which I think is apt, although I'd point out the SEC always doesn't always require a market failure to step in and write a rule. So they'll monitor the environment, and it'll come to their mind, either through talking to constituents or others, that some action may be warranted. Second step is they'll learn more about the environment. They'll design the rule to accomplish a particular purpose. Perhaps it's to cure a market failure, perhaps it's something else, or they may modify an existing rule that's on the book. Third step is they would actually propose that rule to the public, by which I mean they would write the rule down on paper, it would appear in the Federal Register, and any of us could get the rule and read it. What happens then is what's known as a comment period. For 30, 60, 90 days, maybe even longer, the public can comment on that rule. You can write letters, you can come in and talk to the SEC personnel, the staff, the commissioners, and convey your thoughts about that rule. It's a required step of the Administrative Procedures Act, that comment gathering process. Next, the SEC collects those comments and will modify the proposed rule if they think it's appropriate to do so. And it's almost always the case that the rule is modified. Finally, the SEC will issue a final rule. Again, it's in writing. Sometimes they're 200 pages, sometimes they can run to 800 or longer pages. You can get some very long rules, I've heard, Craig. And finally, the SEC will monitor the implementation of the rule. That is, they'll roll it out and they'll see how it's working. They may roll it out in a way that's phased so that they can see the rule come into effect stock by stock, bond by bond, or submarket by submarket, which is actually, by the way, a place that an entity that economists, in particular DERA, can have a role in monitoring whether the rule is having its desired effect. But that's a quick summary of how the rulemaking process works.
Talking of 800-page rules, I came in last year, and as soon as I walked in, we were in the midst of regulation best interest, and it had several components to it, and the whole thing was about 2,000 pages. I said that, gee, you didn't tell me before I signed up for the job, So, but that's how it goes. You are absolutely right, but very nicely summarized, those 6 steps. I will remember that. Craig, maybe you can tell us, there was reference to economic analysis, or the role that Division of Economic and Risk Analysis plays in rulemaking that Eric mentioned. So what is economic analysis, or what is the guidance?
Sure, SP. So when I accepted the job as chief economist, one of the things that happened probably about a month into my tenure was a rule called proxy access was vacated at the SEC on the basis of its economic analysis. The economic analysis was deemed to be arbitrary and capricious and was overturned. And so Mary Shapiro, who was the chairman at the time, basically told me that we were going to have to re-engage on economic analysis, rethink our approach to economic analysis so that the economists were fundamentally involved in its creation from the very earliest inception of the rulemaking. And that was actually quite a bit of a change. I used to analogize the way the economists participated in rulemaking in a way that most of you are familiar with. It's like being a referee for a journal on an academic paper. The rulemaking divisions would pretty much craft the economic analysis, as it were, called a cost-benefit analysis at the time, and it was at what's called the back end of the rule. And so you would, as an economist, you were provided with this draft, you were able to provide comments, and then you would submit your comments, and they would hopefully be incorporated into the final product. One of the real limitations I thought in my early participation as a fellow was that the rule writing divisions saw the referee report, but unlike a referee report, they got to pick and choose which comments they responded to, and they were allowed to ignore everything else. And so some very valid comments I thought I made on proxy access rule, for example, were excised from the final draft, and a little bit of redemption when they were actually pointed to by the DC Circuit Court as things that were missing from the economic analysis. So the rethought is really basic. So while I was there, we put together what is called the current guidance for rulemaking economic analysis at the SEC, some fancy title like that. And it really has just 4 really obvious steps, and it's largely derived from a lot of other agencies, the approaches to doing economic analysis. And the first is establish the baseline. Explain how the current market works, what's going on. That would be step number 1, right? And it ultimately is used as a benchmark that you get to measure the alternatives that you're going to propose to try and address what is number 2, which is a definition of why you need the rule in the first place. I called that a market failure. Eric said it doesn't always have to be a market failure, and I agree with that. But you need to formally establish why a rule is necessary. And then once that has been determined, you then talk about and identify, according to guidance, all the reasonable alternatives. Try to identify not only what solution you're going to propose in the rule, but also other solutions that you could have proposed, but actually chose not to. And that evaluation of the alternatives not only requires you to say what they are, but why you ultimately rejected them. And then the final step, and what has been the biggest focus, has been evaluate the costs and benefits of the rule. And so the big, I think, overarching idea is, as an economist, I can tell you what I think the benefits of the rule are likely to be. That's why we're regulating in the first place. And once you identify these, you talk about the costs as well. And in my view, there's a need to have a qualitative discussion of these costs and benefits. Most of the other agencies are required to adhere to a strict quantification standpoint. So once you identify costs and benefits, you then are expected to go through and quantify, in a sense, tally up the economic effects, and the analysis puts it on a scale and says the benefits outweigh the costs. At the SEC, we don't do that. And it's largely because most of the important benefits and the important costs don't lend themselves to quantification. But you do quantify according to the guidance when you can, and you simply say and explain why you're unable to quantify when that's not possible. In my view, this comes back to this idea of just laying out what the costs and benefits are, so that when the analysis goes up to the commission, I'm not putting it, the chief economist isn't putting this on a scale, but it is forcing the commissioners and a chairman to put it on their own personal scale and be fully informed of what we think all the economic effects of a rule are. Now, one of the key pieces of the guidance, and one that was really, I think, a transformational event at the commission, was the chief economist has to provide his or her concurrence to the economic analysis. It's sort of like a CEO certification in the 10K. SP literally has to sign on the dotted line saying that I concur with the economic analysis. This results in a fairly significant amount of power that's been ceded to the chief economist, right? And so the chief economist is in a much different position than the old days when we were providing referee reports that the authors could ignore. They no longer have that luxury. If we think something's important, and if my staff believes something's important and I agree with them, then you have to be willing to push it all the way to the logical conclusion, which is I may or may not be able to concur with the economic analysis in the rule. All right, so that's the guidance.
I think that nicely summarized. Thank you. So we are running slightly behind time, but not too much. So I'm just letting you know so that we can be even more succinct than we have been. These are big issues. They do take some time. I totally understand. Chester, you have been prolific in commenting on various rulemaking at the SEC. So I think you know more about data than I do, so sometimes I get that feeling. So tell me, what are some of the biggest issues facing the Division of Economic and Risk Analysis at the SEC today?
Well, I think there are a range of important issues, and some of them are in the rulemaking space, and actually some even not. One that comes to mind that's outside the rulemaking space is actually issues associated with issues which are relatively, I think, new or more robust issues associated with the nature of speculative trading and the like, which are getting much more attention in the public arena, perhaps because of the volatility of markets. And on the public side, issues have been pointed to involving Kodak, certainly, and also involving vaccine manufacturers, and raising some interesting issues about whether there were insider trades, whether there's option grants in advance of information. But there's also broader issues about the nature of speculation, the chairman and the staff's intervention in the case of the Hertz bankruptcy, where they almost did an equity offering. I think this whole set of, I think, interesting issues where I think DERR's role may well be front and center. On sort of rulemaking fronts, among the issues that I see as particularly important or timely, so one kind of comes as a byproduct of the COVID, which is the focus in Washington now on China and the implications of dual listing of particularly of Chinese companies and audit standards. And I could imagine that DERR may play an important role with respect to that. I think as a byproduct of the court decision that I referred to earlier about pilots, I think DERR's role will be important with respect to shaping how the commission evolves with respect to methodology, how to kind of get back in the pilot game on the one hand, and on the other hand, kind of using archival studies in a more serious way. The specific issue that the court was addressing, the issue of the fees and rebates and liquidity, the make-take structure, the court ruling basically sort of effectively threw out what was the SEC strategy for moving forward. But I do think there's a recognition that there's important and fundamental conflicts of interest and a lot of excess complexity in that process. And it seems to me DERR's role in shaping that is going to be very important. And finally, I would point to a couple of issues where, because of the possibility of a changing political environment, it's easy to imagine that there might be some revisiting of issues. One is the issue of best interest, where in fact the Democratic platform is calling for a repeal of the best interest regulation, and another is the issue of proxy advisory firms, which which was sort of recently sort of somewhat settled, but you know, it's clear that there's also a conflict along political lines, and I think all of these are issues where the economics are central, and where there's a very important role for DERA as part of the SEC's deliberations, and also potentially, I think, important roles for research both within DERA and beyond.
So let me follow up on that, what you said, because there's a question here from Evisa Bogdani, and that says, what should be some interesting or important areas, topics that SEC policymaking would benefit from research? So let me, since Chester, you just were commenting on 2 topics, do you see those as financial economics researchers shedding light on those issues? Or should it be done internally from the SEC?
Well, I think there is the potential for financial economics researchers to shed light on many of the issues. On the issues associated with speculative trading, a lot of these issues are being flagged by outsiders who are looking at regulatory filings, and there's no reason that researchers can't go down that path. You know, at the same time, I think in terms of some of the bigger, you know, I think in terms of a number of the issues, take the case of proxy advisory firms. I think if anything, outsiders may have an advantage of stepping back and trying to understand the tension between, on the one hand, proxy advisory firms as solving free rider problems, but on the other hand, getting in the way of independent information production. And I think also the issues of how to interpret the differences in the recommendations of these firms as compared to the votes by index funds and other investors. I think there's some interesting things to be gleaned from that about the bias and about how different participants think about governance. I think in the context of the make-take types of issues, there's a very important role for outsiders. I think most of our knowledge base comes from academic studies of different facets of the conflict of interest. I myself have been involved in a study involving price discrimination in the make-take context. I think there's a tremendous potential role for outsiders on many of these questions, and for the most part, the types of data that one would use is available to outsiders. Now, it does point to one other issue that I should flag. One thing where I think the SEC has probably not done a very good job is in facilitating the availability of data. Now, fortunately, FINRA, to some extent, has perhaps done a better job of facilitating access to data, but I do think that's something the Commission could potentially do a better job with respect to.
No, I hear you. I mean, that is about SEC making data available. That has been sort of a recurring theme. So I'm very sympathetic to that point. I know, Chester, he a couple times talked about speculative pricing. I don't know whether there was a reference to cryptocurrency or not, but regardless of that, maybe Eric, you might have some thoughts on what research can do or what rulemaking can do in that context, providing some guidance to the audience here who are prospective PhD students and some others. They might benefit from your vantage standpoint, because you intersect both economics and trading and markets, and this issue in particular is, I think, at the intersection of that. So any thoughts that you might have?
Sure. So I thought about this in advance. Let me give you 3 examples of places in market structure where I think economic analysis is critically important. So the first I'll pick is the issue of fragmentation. So for those of you who aren't familiar with this is the notion that the same security can trade in different markets at the same time. The United States has over 15 different equity exchanges, each regulated by the SEC, some very big, New York Stock Exchange and NASDAQ, others smaller, the Miami International Security Exchange. And they can pretty much all trade the same stock. So you might think, well, you could get different prices at the same time, but forces of arbitrage are obviously going to constrain that. But really, a state of no arbitrage is not sufficient for the mandate of the SEC. The SEC worries in particular about the protection of individual investors and certain fairness issues. And one of the things that contributes to price formation clearly are resting limit orders. Those orders, a lot of them can come from retail investors. And if you don't have good rules of the road and you have 15 different markets operating, let alone what goes on in the broker dealers that are separate, then these resting limit orders that contribute to price formation can get basically run over, by which I mean their better prices cannot, under certain circumstances, may not be honored. And if that's the case, the incentive to place such orders gets attenuated. So what does that mean? Well, that means that there's a place for regulation to decide in a disparate market, a market with 15 exchanges and maybe 80 broker dealers operating one system or another, how are you going to integrate those things together? What rules are you going to craft and what are you going to allow? So we've come through regulation NMS to some answers to that, but that rule is in many ways showing its age. So, to directly address Evisa's question, research that gets at questions of how to protect orders, how to handle the integration of different markets, and in fact, how to address certain questions about what forms of orders are allowable are all very useful. As markets have become more electronic, very unique order forms have crafted that fundamentally algorithmically substitute for what people used to do. Now we encode it in algorithms. And some of those orders can be a bit, poorly structured. So that would be one example. A second question, who owns the price? So this is also a question about equity markets. Sometimes goes by market data. In the old days, you would think of exchanges as making money from their trading fees. They didn't used to be for-profit. Now they are for-profit, and a particularly important source of revenue is the data that exchanges produce as a byproduct of producing trade. So that's both the prices and quantities of trade, and it's the pre-trade information, the quotations and the orders that rest in the book. Those things are incredibly valuable. And the SEC sets the rules of the road by which an exchange can profit from that information through its resale. Now, when you think about it, it's not obvious who owns that information, but the basic framework is that that information can be sold by exchanges. They have the right to price it and sell it. The SEC does not like to be in the business of price regulation. They will avoid that generally at all costs. One of the places they can't avoid it is in market data. So their ability to steer away from price regulation, they can't do it. And that battle has found its way into courts. So the research question then runs to, how should we think about the problem of ways of pricing market data? Who owns it? What should be allowed? What should not be allowed? Typically core data, which are the prices and quotes, top of book quotes, that follows a standard pricing formula. And historically, we've pretty much left it to the exchanges to price within reason their non-core data. That is changing. Court battles have shown that the SEC's ability to do that has changed. And that non-core data, by which I mean depth of book data, is quite valuable and a source of profit. So I think research in that area is profitable. The last one I'd point to is in over-the-counter markets, and I would pick transparency of bond markets. Unlike equity markets where we talk about basis points in bond markets, the spreads are wide, and the cost of trading, especially for small trades, is quite high. I mean, 1 to 2, it can be on the order of multiple percent. So there is no exchange in these markets. And the question is, should the SEC step in? Obviously, the over-the-counter dealer markets have been functioning as such for decades and decades. One answer is no, they should let it be. But there are a range of solutions that are possible. Should we drive toward an exchange for fixed income instruments? That historically hasn't been viable. That would be a pretty extreme policy position, but it's possible. On the other hand, there are some other solutions that are more moderate. We could create a consolidated quotation facility for these bonds. That would be a possible solution. We could set floors or ceilings on that. So maybe only high volume bonds are subject to a different set of rules. We could place obligations on brokers or dealers. And this is all to the goal of what? You've got an inefficient market. Remember, there's not a huge adverse selection problem in these bonds, especially when retail are trading them. So why are retail paying such high costs? Smacks of a market failure, getting back to what Craig said. So the question is this an appropriate place for the SEC to regulate? And if so, is there research that could inform what would happen if, for example, a quotation facility were placed in that market?
Very helpful, very insightful, and clearly issues in trading and markets in particular, these are meaty issues. These are important issues, and you have highlighted both what the challenges are and potential what research can be done. Both of you have done that. I want to give the same opportunity to Craig to see if you want to add anything, or maybe on compliance enforcement or money market funds. Your call. Don't have to cover everything, but whatever you would like to.
Okay, thanks, SP. So I'm going to start out by just offering up a tip, if you will, and that is if you're interested in the types of research opportunities that would be helpful in policymaking space, take a look at rule proposals that the SEC puts out. In every rule proposal, the SEC asks a significant number of questions that are designed to help policymakers come up with a more rigorous, sort of final proposal. And there are frequently ideas on, you can get a sense for where the gaps in the SEC's thinking currently is by looking at the questions they're asking commenters to help them answer. And so I think that would be the thing that I would recommend, is find a topic you're interested in. If you think it's a rule where you have some research interest, just take a look at the comments that are being offered. Now, in terms of academic input, I think the best thing that happens in the interchange that takes place isn't so much you looking at the SEC, but the SEC looking at research output itself. So when my staff would put together a new rule, the first thing we would do is we would survey the academic literature to understand what fellow academics were saying about some of the issues involved. And those articles are highly influential in forming kind of the way an economist thinks about what the main issues are. SP mentioned money market funds. I think that was one of the rules that I spent a significant amount of time working on while I was at the commission. We did a lot of data analysis. We did a lot of theoretical modeling on money market funds. And I think at the end of the day, the economic analysis that was being discussed was actually highly instrumental in the final form that the rule took. And so I think that rule is a fairly significant achievement by the staff. One of the issues that always exists around money market funds is there's a natural tension that takes place between different regulators. So the SEC does look at money market funds as just another class of a mutual fund. The Federal Reserve tends to view money market funds as being special purpose banks, right? Borrowing and lending. And so whereas the Fed regulates banks, the SEC regulates money market funds through a disclosure-based mandate, whereas the Fed uses a prudential-based mandate. This creates natural tensions. But the rule that the SEC promulgated is one that was completely consistent, I felt, with sort of the disclosure approach that the SEC has, and that it's organizing mandate. So one of the things that happened during the pandemic was that a lot of corporations hit their lines of credit, right, which seriously disrupted the market for commercial paper and created a lot of stress on the money market funds. And there were a lot of redemptions out of money market funds as companies decided they just wanted their cash, right? And so would there be another run on money market funds? We'll never know, because the Fed stepped in very early in the process and supported money market funds. I guess I personally thought it would have been a really interesting experiment to see whether the rules that we promulgated were actually robust enough to help in that. But we'll never know because we didn't see it. So just a couple ideas there, SP.
Thank you. Thank you again. I have a question here from Ehud Ron, and it is directed to Chester. Says, I may have misunderstood Chester's comment here, but let me ask nevertheless, why are Democrats opposed to the best interest rule for advisory services?
Well, you know, I think there were a variety of criticisms of the rule, and even though I think of myself as relatively nonpartisan, I was among critics, but among critics because I felt that I and a number of other chief economists felt that the economic analysis in the rulemaking proposal was thin. I think that the reason there's such a partisan divide kind of goes back to the Obama administration and the Labor Department rule. The Labor Department rule was going to impose a fiduciary standard on brokers, and it's clear that the best interest rule is designed to be somewhat short of a full fiduciary standard, and I think that's one reason why on the Democratic side there's a lot of opposition. But maybe it's better to ask Democrats who were involved in the platform in their party's platform. But I think another criticism of the rule also may be associated with the label best interest. I think it's perhaps hard to go from the rule which doesn't follow a fiduciary standard and to say that the broker necessarily has a best interest obligation. I think the terminology is one of the things that has really stirred the pot a bit in terms of political opposition. But I really see myself as sort of a bystander to that, and I really would encourage one to reach out to folks involved. But I do think there's likely that this is an issue that may be revisited, or alternatively that the enforcement. Another possibility is that the rule is left in place, but the enforcement regime maybe is ratcheted up a notch further. That's another possible outcome, because there is a lot of interpretive issues associated with the rule.
Okay. Well, thank you. I knew I couldn't resist not asking that question, given so I obviously cannot comment.
SP, wasn't that perhaps your first rulemaking at the commission?
It was, and the economic analysis was something that I inherited. Not that I'm defensive, but
no, but that's why I also emphasized the chief economist letter was specifically at the proposal stage.
Yes. So no, I know.
And we did not try to weigh in. We did not try to weigh in on the final rule.
I walked into the SEC, and one of the early ones I saw was that letter from all of you, and I said, gee, all of these guys, they are not too happy with it, so let me take a look at it. So that generated a lot of discussion. I know it was constructively intended, so I'm grateful for the nudge that you provided. So thank you. Eric, anything you want to add to that? So the issue of current research issues or anything else? Don't mean to put you on the spot or force you to say, but otherwise we can move on to other things. So.
Other areas, we haven't really mentioned, we've mentioned money market funds, but the SEC comprehensively regulates both advisors and other pooled kind of vehicles, mutual funds and variable annuities. So, in that space, there are other issues. So, for example, up right now are issues about the use of derivatives by mutual funds and how those should be sort of regulate it. So it's an old framework that exists, and I would just and the SEC is they're going to move and they're going to act on this probably before any new research comes out. But I would just point to it as an example of where understanding funds use of derivatives would be something that would, I think, be welcome. There's sufficient data on it, I think, to get some things done. And, it's probably a fruitful place to at least take a look. There's not been a ton done in that area.
I know we have only a few minutes left. And I'm looking at questions are there. Question to Craig I received. Do you think what happened in the money market funds in March was a run by those large corporations? Do you think that the Fed stepped in because they think there was a run going on? Will there be further reforms on the money market funds?
I haven't looked at the data myself, so I would just be speculating on where the run took place. But if it's similar to what happened after Lehman Brothers cratered, then one would assume that most of the redemption was taking place in the prime money market fund space for the institutional prime funds rather than retail funds. So retail investors tend to be slow to move. I don't think this was probably an exception, but I'm just guessing based on what I saw in the past. Do we need additional regulation? I would say no. We never gave the existing regulation a chance to actually work. So until we actually have a real test of whether redemption fees and gates are an appropriate response to blocking runs, I think what I would have liked to have seen is just let the market operate, and see it. As an economist, I would have liked to have seen whether the rules I worked so hard on actually were effective or not.
Well, this is an interesting question that I bet you would have views on. Laura Starks, highly regarded finance professor, she asked, what about the proposed change in the 13F rules? Many finance, accounting, and economics faculty are against the change because it could hide what is really going on with institutional investors.
Can I jump in on this one, SP?
What?
I hate to jump in, but I basically, with my colleague Ben Munyon at Vanderbilt, we have we're putting together a database of all the 13F filings, right? And one of the interesting things about 13F is that the current publicly available versions of it just look at equity, but many investors invest in derivatives, invest in bonds, and the database we're putting together is bringing all of those securities into play. So I personally don't understand what the incentive for changing the 13F standards is. I agree with the academics. It can be a very useful database that allows us to better understand how that segment of the market works, and to sort of arbitrarily sort of raise the limits and allow a lot of funds to no longer have to report in seems to destroy your ability as chief economist to engage in economic analysis to support a rule. So I think you want a database that is consistent over time, and that you don't have to think about, well, in this period we eliminated all these funds. I actually believe that once a database is in place, you should maintain it. I can't believe that the costs of actually putting this out are that prohibitive, right? And so I think the actual compliance costs are totally overstated by those that don't want to be involved. I think it's more, we don't want to be transparent. And I don't think that's beneficial for markets.
Yeah. So if I could just add to what Craig said. So I was surprised to read about this this proposal in the last month or so. I was very surprised. Now if there is something to the case about cost, that's going to be at some margin. But what struck me here was that the proposed cutoff was going to move from $100 million fund to a $3.5 billion fund. And that's part of what struck me as surprising. If there was, now I also understand that the rule hadn't been updated in some period of time. Okay. But it has been an important source of information in our markets. I think it's not only from a researcher's perspective, but it's something that investors are looking to come the middle of the quarter as to what the most prominent investors did previously, and I think that sort of served an important role as well. So there might be, if there is a case, and there might be a case on cost grounds, but that would suggest maybe some tinkering at the margin in terms of trying to be persuasive.
Frankly, I think that they should actually improve 13F. And, right now, you only have to report long positions. I think why an investment doesn't have to also include short positions they have seems to completely misrepresent a firm that's a long-short fund, for example.
Well, I tend to agree with that. I thought the efforts that Craig was describing on the derivatives and the funds sound like really great efforts, and we'll look forward to seeing the availability of that information. On the short sale point, this is something I reflected on a little bit, because in the week after the crisis, and I wasn't at the commission then, but in the week after the crisis, I remember at some point there was the threat, put in quotes, to require disclosure of the short positions. And I have to say, in that context, I was somewhat negative about that. And the reason I was negative is I thought it was punitive. I thought in that context, scoping in the short sales was punitive, and in particular was part of a campaign orchestrated perhaps even by Wall Street firms to blame their problems on short sellers. And my view is that, my broader view is that short sellers are fundamental to the integrity of our capital markets because they prevent investors from buying overpriced stocks. So that would be kind of one, but my views about the short sale positions was partially motivated by that particular context. Now, I think what some regulators would say would be that the impetus originally for 13F was in the context of issues of corporate control. And that's why the focus is on long equity positions, such as it is. But I'm generally supportive of the points that Craig was making.
This conversation has made me acutely aware of how much I miss the academic freedom. So we have only 2 minutes left, and this is 30-second round, if you will. Any last advice to the audience here? Let me begin with Craig.
So, okay, one quick idea. We talked about research ideas earlier. I think it would be interesting to look at what has happened in the pandemic with many of the brokerage firms like Schwab, Vanguard, Robinhood, dropping their commissions to zero, right? Okay. What impact has that had on equity prices? Has that had a material impact on volatility in markets? Can you attribute some of that volatility to the participation of retail investors, or as we kind of always, at least how I think, retail investors aren't really marginal in a lot of the pricing. So I think there's a lot of interesting research ideas around this change to zero brokerage commissions.
I'd echo one
Eric,
point.
any last advice?
Yeah.
Okay.
I'd echo one point that I heard on the prior panel, which is to emphasize to young researchers, it's incredibly important to take risks and be ambitious. But this is a space where I think one can do so, because there is, if you're ambitious and you're thinking deeply, there is the potential of pulling together a variety of interesting data sets to ask new and important questions.
Yeah, SP, let me just say, bring up a slightly different point. I'm going to give a plug for your office.
Okay.
You know, we're obviously three people who've spent time at the SEC. And while it's not appropriate to do that for a young faculty member who's just getting started, at some point it's an interesting career move to come there. Everyone, you know, initially thinks it's all about the data. It's not. Working at the SEC, spending a year or two there as a visiting faculty member, I think it's about the ideas. I think it's getting to talk to people. I think it's learning about the markets in different ways. It's a productive thing to do. And another productive thing to do, I know, is to come to DERA or us in the SEC and give a paper. You get comments at the SEC that you're not going to get in other places. And I think from a research perspective, that's helpful. So if you get an invite to give a paper at the SEC, take it.
With that, you know, on that note, I can't thank you enough for your insights, for your candor. And Scott, I want to thank you for organizing this event. I think the audience couldn't have benefited more from 1 hour than this precious 1 hour. So thank you, thank you, thank you to all my predecessors. I appreciate it. Thank you, Scott. Bye-bye.
Thanks.
Yeah.